Compromise of 1850, Clay's resolutions of January 29, 1850, it being desirable for the peace, concord, and harmony of the Union of these states to settle and adjust amicably all existing questions of controversy between them arising out of the institution of slavery upon a fair, equitable, and just basis, therefore, 1. Resolved, that California, with suitable boundaries, ought, upon her application, to be admitted as one of the states of this Union, without the imposition by Congress of any restriction in respect to the exclusion or introduction of slavery within those boundaries. 2. Resolved, that as slavery does not exist by law, and is not likely to be introduced into any of the territory acquired by the United States from the Republic of Mexico, it is inexpedient for Congress to provide by law, either for its introduction into, or exclusion from, any part of the said territory, and that appropriate territorial governments ought to be established by Congress in all of the said territory, not assigned as the boundaries of the proposed state of California, without the adoption of any restriction or condition on the subject of slavery. 3. Resolved, that the western boundary of the state of Texas ought to be fixed on the Rio del Norte, commencing 1 marine league from its mouth, and running up that river to the southern line of New Mexico, thence with that line eastwardly, and so continuing in the same direction to the line as established between the United States and Spain, excluding any portion of New Mexico, whether lying on the east or west of that river. 4. Resolved, that it be proposed to the state of Texas that the United States will provide for the payment of all that portion of the legitimate and bona fide public debt of that state contracted prior to its annexation to the United States, and for which the duties on foreign imports were pledged by the said state to its creditors, not exceeding the sum of dollars, in consideration of the said duties so pledged having been no longer applicable to that object after the said annexation, but having thenceforward become payable to the United States, and upon the condition, also, that the said state of Texas shall, by some solemn and authentic act of her legislature, or of a convention, relinquish to the United States any claim which it has to any part of New Mexico. 5. Resolved, that it is inexpedient to abolish slavery in the District of Columbia whilst that institution continues to exist in the state of Maryland, without the consent of that state, without the consent of the people of the district, and without just compensation to the owners of slaves within the district. 6. But, resolved, that it is expedient to prohibit, within the district, the slave trade and slaves brought into it from states or places beyond the limits of the district, either to be sold therein as merchandise, or to be transported to other markets without the District of Columbia. 7. Resolved, that more effectual provision ought to be made by law, according to the requirement of the Constitution, for the restitution and delivery of persons bound to service or labor in any state, who may escape into any other state or territory in the Union. And 8. Resolved, that Congress has no power to promote or obstruct the trade in slaves between the slave-holding states, but that the admission or exclusion of slaves brought from one into another of them depends exclusively upon their own particular laws. An act proposing to the state of Texas the establishment of her northern and western boundaries, the relinquishment, by the said state, of all territory claimed by her exterior to said boundaries, and of all her claims upon the United States, and to establish a territorial government for New Mexico, be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled, that the following propositions shall be, and the same hereby are, offered to the state of Texas, which, when agreed to by the said state, in an act passed by the General Assembly, shall be binding and obligatory upon the United States, and upon the said state of Texas, provided the said agreement by the said General Assembly shall be given on, or before the 1st day of December, 1850. First, the state of Texas will agree that her boundary on the north shall commence at the point at which the meridian of 100 degrees west from Greenwich is intersected by the parallel of 36 degrees 30 minutes north latitude, and shall run from said point due west to the meridian of 103 degrees west from Greenwich. Thence her boundary shall run due south to the 32nd degree of north latitude, thence on the said parallel of 32 degrees of north latitude to the Rio Bravo del Norte, and thence with the channel of said river to the Gulf of Mexico. Second, the state of Texas cedes to the United States all her claim to territory exterior to the limits and boundaries which she agrees to establish by the first article of this agreement. Third, the state of Texas relinquishes all claim upon the United States for liability of the debts of Texas, and for compensation or indemnity for the surrender to the United States of her ships, forts, arsenals, custom house revenue, arms, and munitions of war, and public buildings with their sites, which became the property of the United States at the time of the annexation. Fourth, the United States, in consideration of said establishment of boundaries, cession of claim to territory, and relinquishment of claims, will pay to the state of Texas the sum of $10 million in a stock bearing 5% interest, and redeemable at the end of 14 years, the interest payable half-yearly at the Treasury of the United States. Fifth, immediately after the President of the United States shall have been furnished with an authentic copy of the Act of the General Assembly of Texas accepting these propositions, he shall cause the stock to be issued in favor of the state of Texas, as provided for in the fourth article of this agreement, provided, also, that no more than 5 million of said stock shall be issued until the creditors of the state holding bonds and other certificates of stock of Texas, for which duties on imports were specially pledged, shall first file at the Treasury of the United States releases of all claim against the United States for or on account of said bonds or certificates in such form as shall be prescribed by the Secretary of the Treasury and approved by the President of the United States, provided that nothing herein contained shall be construed to impair or qualify anything contained in the third article of the second section of the joint resolution for annexing Texas to the United States, approved March 1st, 1845, either as regards the number of states that may hereafter be formed out of the state of Texas, or otherwise. Section 2. And be it further enacted, that all that portion of the territory of the United States bounded, as follows, beginning at a point in the Colorado River, where the boundary line with the Republic of Mexico crosses the same, thence eastwardly with the said boundary line to the Rio Grande, thence following the main channel of said river the parallel of the 32nd degree of north latitude, thence east with said degree to its intersection with the 103rd degree of longitude west of Greenwich, thence north with said degree of longitude to the parallel of 38th degree of north latitude, thence west with said parallel to the summit of the Sierra Madre, thence south with the crest of said mountains to the 37th parallel of north latitude, thence west with said parallel to its intersection with the boundary line of the state of California, thence with said boundary line to the place of beginning, B, and the same is hereby erected into a temporary government by the name of the Territory of New Mexico, provided that nothing in this act contained shall be construed to inhibit the government of the United States from dividing said territory into 2 or more territories, in such manner, and at such times as Congress shall deem convenient and proper, or from attaching any portion thereof to any other territory or state, and provided, further, that, when admitted as a state, the said territory, or any portion of the same, shall be received into the Union, with or without slavery, as their Constitution may prescribe at the time of their admission. Section 3. And be it further enacted, that the executive power and authority in and over said territory of New Mexico shall be vested in a governor, who shall hold his office for 4 years, and until his successor shall be appointed and qualified, unless sooner removed by the President of the United States. The governor shall reside within said territory, shall be commander-in-chief of the militia thereof, shall perform the duties, and receive the emoluments of superintendent of Indian affairs, and shall approve all laws passed by the legislative assembly, before they shall take effect. He may grant pardons for offenses against the laws of said territory, and reprieves for offenses against the laws of the United States, until the decision of the President can be made known thereon. He shall commission all officers, who shall be appointed to office, under the laws of the said territory, and shall take care that the laws be faithfully executed.